Hey, boy! Show your face!
Those were the final words of 37-year-old poet and mother of three, Renee Nicole Good, before a federal tactical operation in South Minneapolis turned fatal. Within 47 seconds, a routine vehicle stop on a snowy Portland Avenue escalated into a shooting that has reignited a fierce national debate over federal immunity. Today, we're going beyond the protests and the headlines. We are analyzing the raw footage through the lens of the Supreme Court's objective reasonableness standard and the 2025 Barnes v. Felix precedent. Was this a split-second act of self-defense or a catastrophic failure of tactical procedure? You decide. To understand the defense's position, we have to look at the objective reasonableness standard established in Graham v. Connor. The law doesn't ask what a civilian thinks in their living room. It asks what a reasonable officer would do in those chaotic seconds on Portland Avenue. ICE training classifies a moving vehicle as a deadly weapon, regardless of speed. Why? Because even at 5 miles per hour, a 2-ton SUV possesses enough torque to crush a human body. Add to this the fact that Agent Ross was reportedly dragged by a vehicle just 6 months prior. In his mind, when that Honda Pilot began to roll, it wasn't just a car moving, it was a repeating trauma. The defense will argue that his reaction was a conditioned, split-second response to a perceived lethal threat. But this is where the prosecution's argument, bolstered by the 2025 Barnes v. Felix precedent, gains ground. The core question isn't just about the moment the shots were fired, but the moments leading up to it, the pre-seizure conduct. Analysis of the bystander footage shows Agent Ross moving into the path of the vehicle as it attempted to maneuver. Legal experts ask, if Ross had maintained a tactical position at the side of the SUV, would he have ever been in danger? If an officer's own tactical errors, like standing directly in front of a running car, unnecessarily create the danger, then the use of deadly force may no longer be considered reasonable. This is what we call officer-created jeopardy. Building on the tactical error of his positioning, 3 additional factors further erode the self-defense narrative. First, the persistence of threat. Forensic analysis of the shots fired reveals a troubling timeline. The second and third rounds were discharged after the front of the SUV had already passed Agent Ross, entering through the driver's side window. Lawfully, deadly force is a fading window. Once the vehicle is no longer an imminent strike hazard, the justification to shoot begins to vanish. Second, pre-encounter conduct. Every split-second decision is colored by what came before. Seconds prior to the escalation, Renee Good was cordial and showed no animosity. It is difficult for a reasonable officer to infer lethal hostile intent from a subject who has been nothing but cooperative just moments before the panic set in. Finally, the post-incident language. The vulgarity uttered by Agent Ross immediately after the shooting provides a chilling window into his state of mind. To a fact finder, these words may reflect a mindset of compelled control rather than a man acting out of a fear of death. If the motive was dominance over compliance, the foundation of a self-defense claim fundamentally collapses. Then there is the human element that a jury cannot ignore. Renee Good was a 37-year-old mother, a published poet, and a U.S. citizen with no violent criminal history. She wasn't a fleeing felon. She was a woman in a high-stress encounter who stated she wasn't mad seconds before the shots. This creates a massive legal friction. Did the agents follow the ICE use of force policy, which generally discourages firing at moving vehicles unless no other option exists? In a sanctuary city like Minneapolis, the bar for federal agents is under intense scrutiny. Was there a failure in communication or a failure in policy? As Minneapolis braces for what will likely be the most significant civil rights trial of 2026, the community is left mourning a mother and a poet. The investigation into Special Agent Jonathan Ross is ongoing, and while the Department of Homeland Security stands by its agent, the legal fallout is just beginning. This case forces us to confront a difficult reality: the thin line between officer safety and public accountability. Does the split-second protection of Graham versus Connor cover a situation where the officer's own tactics put him in harm's way? Or will the Barnes versus Felix precedent change how federal agents operate on American streets forever? Now it's your turn. You've seen the footage, and you've heard the legal standards. Was this a justifiable use of force or a tragic, avoidable error? Let us know your thoughts in the comments below. We read every single one. If you found this legal breakdown helpful, hit the like button and subscribe for more in-depth analysis of the stories that shape our justice system. I'm Blue Line Raw, and thanks for watching.